Tonight, we are just 2 days from the release of the Mueller report. A former top advisor to President Clinton, he'll join us to compare how this is being handled now compared to the Starr report back then. Also, Congressman Hakeem Jeffries of New York, he's one of the top Democrats in the House. He'll join us to talk about how Congress is trying to put checks and balances on the president, the ongoing probes into the president, and much, much more. Then, the measles outbreak, believe it or not, is going from bad to worse. We'll take a look at just how bad things are and how local leaders are trying to respond. Good evening and welcome to RFL. I am Richard French. In less than 48 hours from now, the Mueller report will be released, at least in part. We do not know how much of it we in fact will see, as it's expected to be heavily redacted. That will set the stage for what could turn into a protracted legal battle. House Democrats, they've already threatened to issue a subpoena so they can get the report in its entirety. If that doesn't work, this could head to court, and it could be, as I said, a long fight. Now, contrast that, if you will, to 20 years ago when the independent counsel Ken Starr's report was released to the public in its entirety. It was downloaded so often, government servers crashed. Well, my next guest, he was a special advisor to President Clinton, and he's also a former federal prosecutor in his own right. Nelson Cunningham joins us now. Nelson, thank you for the time.
It's my pleasure to be here. Thanks.
Well, should we, the people, the general public here, probably prepare themselves to be disappointed given the expected redactions and how hard it's going to be to really consume a 400-page document in its entirety, given how much will be left out?
Well, I think it's fair to assume that Mr. Barr has not spent the last 4 weeks doing a light edit on the Mueller report. He and his attorneys have gone over this exhaustively. Barr laid out 4 categories of information he'd be looking to exclude. Depending on exactly how he applies that, we could see something that's got a lot of black, a little black, but it may be pretty hard to understand the full narrative flow given how much has been cut out.
Well, let me ask you about Mr. Barr, because in the intervening weeks, there has been a lot made, including some members of Mueller's team. Some of the prosecutors believe that his summary was not reflective of their work product. He also, threw the exonerated term out when that clearly wasn't stated from the Mueller report. And people are saying he's not an honest broker. I've also read some of what you've written, which is to say these 4 categories that he can redact from, that's law. And you can't get after the man if he's following the law. How do you look at Barr as we get ready for Thursday?
Well, I think we have to be balanced and we have to be fair. I served in the Justice Department when Bill Barr was in senior positions 25 years ago. I served in the department when he was the Attorney General under Bush 41. He had a great reputation. May not be where I am politically, but on law enforcement issues, he had a reputation as a straight shooter and as a mainstream lawyer and law enforcement official. I certainly thought that when he came back and took this job for the second time, remember, he had this job 30 years ago. I believed that he would not come back to take this job just to throw away his reputation. And I'm hoping that he does not do that. Having said that, in 2 years of Rod Rosenstein's supervision of Mueller and of this case, I really cannot think of any instance in which I questioned Rosenstein's judgment, his public statements, or his support for basic law enforcement principles and policies. And yet, with Barr, in the last 5 or 6 weeks alone, I can think of 4 or 5 things that have really given me pause. I have an open mind, a very open mind on what he will do with the redactions, but I frankly would have been more confident if Rod Rosenstein were the only one wielding that black pen.
I saw a piece that you penned a couple weeks ago in Politico, and at least the takeaway for me, Nelson, was, listen, this is going to play out as it'll play out on Thursday. But if we go back to Watergate, we in effect have precedent that's been set that says the House Judiciary, or I should say the Judiciary Committees, as well as the Intelligence Committees, have every right to see the full unredacted report, whether it be the Gang of Eight or the committees in total. Maybe it's not for public consumption yet, but they have that as part of their job. We went through this fight in Watergate. Can you explain, really with an en banc decision by the district court there in D.C., what they decided then? Because certainly the folks in the Nixon administration argued that this shouldn't have been released to them, but at the end the court said it should. What was decided and why, and how do you think it applies to 2019?
Yeah, so this was in early 1974, and Leon Jaworski, who was the Watergate special prosecutor, and his grand jury finished their work. Jaworski produced a report, which is now known as the roadmap, which essentially tied together all of the evidence. And he bundled that together with the grand jury, the underlying grand jury evidence, the Nixon tapes and other evidence. And the House Judiciary Committee, under Peter Rodino, subpoenaed that report and the underlying evidence. It went to court. Judge John Sirica, the celebrated judge of many of the Watergate proceedings, carefully considered that. He issued a long decision saying that the grand jury rules should not forbid dissemination of a report when it's going to a quasi-judicial proceeding, such as the impeachment proceedings that were then going on in the House of Representatives. That decision went up to the D.C. Circuit, the federal circuit court that rules here in the District of Columbia. That court took the matter en banc, meaning every judge of the circuit sat, listened to it, and by 5-1 decision, they ruled that Judge Sirica was right and that grand jury restrictions would not apply to a report that was going to a House Judiciary Committee in these circumstances. By the way, the only dissenter was a Nixon appointee who just joined the court 1 or 2 years before. En banc decisions are particularly strong evidence and, particularly strong precedent, and a court will only rarely overturn an en banc decision of its own court. In fact, just 2 weeks ago, the D.C. Circuit had occasion to revisit the rules on grand jury secrecy, and in a footnote, they explicitly affirmed that decision reached in 1974 by the D.C. Circuit en banc. So we have precedent going back just 2 weeks ago saying that 1974 decision still applies. Watergate was a very special circumstance, but boy, the House Judiciary Committee going after the Mueller report and underlying evidence, it's the exact same special circumstance. I don't see how a judge would do anything but rule that this should go to the House Judiciary Committee, which, by the way, would have to keep it secret. They could not disseminate this information because it does contain grand jury information. It does contain classified information, but they could use it as their own roadmap for their own investigation. Here are the witnesses. Here's the evidence they gave. Let's subpoena these documents. Let's assemble our own case, and let's decide where the chips fall. I think the law could not be clearer that the Judiciary Committee is entitled to the report and to the underlying evidence. The same is true for the Intelligence Committee, but for somewhat different reasons.
So let's say Schiff and Nadler, they basically follow the exact script that you say. How quickly could that be fast-tracked so they get their hands in the report?
Well, they should be able to get a district court judge to rule on their requests within a matter of weeks. The law is straightforward. For the Intelligence Committee, it's even more straightforward because Rule 6E specifically says, that's the grand jury secrecy rule, specifically says, this does not apply to information given to intelligence officials. That was passed after September 11, 2001, when it turned out that the FBI on the law enforcement side had information that could have been enormously useful to intelligence officials, but they had not turned it over because of this grand jury secrecy provision. We decided at that time, well, that makes no sense. We took down that wall. And so Schiff has a clear lockdown case that he can get the report as well as the underlying information without redactions and without restrictions. A district court judge ought to be able to find that pretty quickly. Then it's a matter of how hard the administration would seek to fight this, how far they would take it up on appeal. I think Donald Trump believes that the Supreme Court, having now made two very conservative appointments to that court, the Supreme Court is his court, and he would be hopeful for a favorable decision from that court. But I have to tell you, given the 1974 Watergate precedent and given the clear language of Rule 6E, I don't see how any conservative majority could keep this information out of the hands of the judiciary and the intelligence committees.
Finally, Nelson, I've had former federal prosecutor after former prosecutor tell me, Rich, as important as Thursday is going to be, just wait till you see what comes out of the Southern or the Eastern District courts. A, do you agree with them? And B, will Thursday, regardless of what form it comes out, will that impact any of their independent investigations?
Well, first of all, the Southern District of New York, my old district, the Eastern District of Virginia, across the river from us here in Washington, these are among the most professional and highly esteemed prosecutors' offices that we have. I expect that they will put their heads down and follow the facts and the evidence where they lead them, no matter what, without paying much attention to the public fanfare, and certainly without paying much attention from what they are hearing from the White House or from Main Justice. The nickname for my old district, the Southern District of New York, is the Sovereign District of New York, because we so often fought against the instructions that we got from the Justice Department and went our own way. These prosecutors are chasing some pretty important cases, the Michael Cohen cases, the hush money cases, all of underlying information relating to the Trump Foundation, the Trump organization, all the business dealings, the tax dealings. Who knows where that will lead? But that will go so far, could go so far beyond where Mueller's fairly narrow remit went. We have yet to see where it'll go, but that could be extraordinary and could be extensive.
Nelson Cunningham, I so appreciate the time. Thank you so much tonight.
It's my pleasure. Thank you.
All right, everyone, when we come back, we'll be joined by a member of the powerful House Judiciary Committee, a committee we just discussed, and he's also head of the Democratic caucus. He'll join us, Congressman Hakeem Jeffries. He'll talk about the congressional investigations into President Trump and a whole lot more.